You're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No.
Your Honor, if I may.
Welcome to a dramatic trial where the line between freedom and prison is thinner than ever. The accused, while accepting the role of the murderer, continues down a path of violence, facing fines and an undefined yet troubling penalty. Is the error in judgment sealing the fate of this case? Follow this gripping story to uncover the truth and witness the final verdict unfold.
You are on bond for murder, and you've now picked up an assault case. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
Thank you, Your Honor. On April 27th, 2025, in Harris County, Texas, officers were dispatched to a disturbance/unknown weapon call. The complaining witness stated she is part of the nursing staff and that the defendant has been asked to leave on multiple occasions and refuses to do so. The complaining witness stated that the defendant was attempting to get her grandfather to sign over power of attorney to her, but the staff would not allow this due to the grandfather being diagnosed with dementia. The complaining witness stated that the defendant used force on the complaining witness to get her to leave the grandfather's room. The complaining witness states that the defendant put her hands on the complaining witness's face and pushed it back. The defendant was positively identified by the complaining witness and her Texas ID number.
You say that there was any pain? She pushed in the face. This is an assault, right? There has to be some kind of injury or pain.
She did state that she felt pain in the dim summary.
Okay. Ms. Taylor, I'm going to find that there's sufficient probable cause to go forward with the case. Now, you're saying there's a bond violation in this case?
Yes, Judge, it's in the...
Michael, have you seen this? And how did you already get appointed to this case?
Your Honor, I was appointed sometime very recently on this case. I received a text. I don't know what day it was, but I received
it looks like it was the 29th, which was Tuesday. But how was he appointed a lawyer?
I'm thinking when she was in the holdover.
No. How is she, I mean, I don't understand. Well, regardless, I guess I'm glad that you're appointed because right now she's got bond violations. She was ordered by the magistrate.
I wasn't aware of that, Judge.
I'm sorry?
I wasn't aware of a BVR in this case. I actually have another BVR today before the court.
I know that. Yeah, we got you. We'll deal with that one next, but you're on bond for murder. You were ordered by the magistrate to have a GPS monitor. You have violated those conditions. Unacceptable. I'm revoking your bond. She goes with you. No.
Your Honor, if I may.
Yeah.
Your Honor, she just was released because I met her in the holdover earlier this week, and she could not have been out of jail more than a day, two at the most. Would the court allow her to leave right now to get the device?
No. Did she not get the device?
Judge, there was a conflict, that's why the DVR was submitted, felony, so the magistrate ordered bond conditions, but the curfew times were not aligning with the felony conditions.
So what? I mean, you still have to abide by the conditions. I mean, what did they say the conditions were?
I have the paper up right there.
I'm not asking you to say anything, Ms. Taylor. The only thing I want is I want my city protected. You're on bond for this serious case, and now you picked up an assault. I mean, you were ordered to have certain conditions. You must abide by these conditions. She received conditions of bond on April 28, 2025 that ordered a GPS device with a curfew of 7 p.m. to 7 a.m. On May 1st, she had an unapproved enter at 7:52 p.m. and then left again at 8:51 until basically 9 o'clock at night.
Yes, Judge, and on the felony conditions, I'm looking at them right now, their curfew is from 12 a.m. to 6 a.m. So that's where it's conflicting. So the magistrate ordered from 7 p.m. to 7 a.m. and on felony, their curfew was 12 a.m. to 6 a.m.
I mean, she still has to follow conditions, right? There may be conflicting, but You know, you abide by the conditions and then you come to court and you ask to, you know, do something or maybe make them align, but you just don't do whatever you want to do and think, okay, nothing's going to happen. You're on bond for 2 serious cases.
Your Honor, if I may again,
Sure.
this is a brand new case. Could the court admonish her? Because the amount of time, I understand that.
Michael, she's on bond for murder. She's lucky to even have a bond, and now she picks up an assault. She's ordered to have a curfew, and she's just doing whatever the hell she wants to do.
In this case, Judge, that's before your court. This is a brand new case, and this is her first time having any issues while on your bond, Judge. Would the court be willing to admonish her not to leave her home even for short periods of time?
And we're not going to do this again. You have one chance to make it right. We give you 2 weeks from the date of your release to go turn yourself into Louisiana. You must turn yourself in. Not, I'm going to go do this. I'm going to hire a lawyer. I'm going to try to get a bond. No.
Just go turn myself.
Go turn yourself in. The other thing I'm going to tell you is that Murphy's Law, you know, what can happen will happen. Don't wait until the last day. You know what? I'm going to go turn myself in now. I don't care if you car trouble, abducted by aliens. Don't matter.
Welcome to the court hearing, where a woman's fate hangs in the balance between freedom and responsibility. Will the judge show mercy, or will her past convictions destroy her second chance? Tune in and witness the tense discussions and the final life-changing decision.
Holman, come up.
No, he's in jail, Judge.
Oh, she's in jail. Oh. What do you want to do?
You just need to revoke the, I guess, raise the bonds, or she's on bond on the new evading case.
Yeah, okay. I'll whatever you want, Lori, you know?
All right, I'll just reset her the next week.
Okay, you got it.
Thank
So,
you.
what day you want?
The 8th.
You hear that, Vic?
Who?
Holman.
Yes.
Yeah, okay, you're good. Johnson, you said, right?
Yes,
All right, good morning, Ms. Johnson. So it looks like you are wanted out of the state of Louisiana for a larceny. It's a misdemeanor, am I right?
Yes, Your Honor.
Okay. Your lawyer's asking for me to set you a bond. I don't know. I need to know more about you. My primary concern, number one, are you going to go back to Louisiana if we give you a bond? Number two, are you going to leave a wake of destruction? Because that's what we don't want. We don't want you to be danger. If you're danger, you know. Well, I know that you're going to tell me it's little bunnies jumping in the woods. Everybody does, right? But how you look on paper really tells me who you are.
Your Honor, the demanding jurisdiction requested no bond because the demanding jurisdiction showed that she is also wanted for failure to appear for a DWI, and the FTA was issued out from Caddo Parish on July 21st, 2022, but then she picked up this larceny within the last couple of months this year. While that was an FTA, state requests that there's sufficient bail be set for the fugitive to be returned to their main jurisdiction. State requests a $10,000 bond because of the fact that it's a 3-year-old FTA. On top
This case is 3 years old.
No. The other
The DWI.
pending, right? She also is wanted for a DWI out of the same parish, but this specific fugitive case is for the larceny. I'm just highlighting the reasons for the higher bail. It's because the older case was 3 years
See
old.
what I mean? That's what I'm saying, you know? Yeah, I know what you're going to tell me, but paper tells me another thing. And that's a big problem. The DWI has been open for 3 years. Now, the only reason we have you is so are you okay with the bond then?
Okay, with a bond, just a sufficient bond that she return herself, Your Honor.
Okay.
Yes,
Judge, we wouldn't be opposed to 10,000 if you could set it at that.
Okay, I want you to understand that I don't play games. I'm not going to do this repeatedly. I can set you a bond now, but if you don't go, I'm going to revoke this bond. I will set it at 0. And this time I'm going to hold you until Louisiana comes and gets you. And we're not going to do this again. You have one chance to make it right. We give you 2 weeks from the date of your release to go turn yourself into Louisiana. You must turn yourself in. Not, I'm going to go do this. I'm going to hire a lawyer. I'm going to try to get a bond. No.
just go turn myself.
Go turn yourself in. The other thing I'm going to tell you is that Murphy's Law, You know, what can happen will happen. Don't wait until the last day. You know what? I'm going to go turn myself in now. I don't care if you car trouble, abducted by aliens. Don't matter. As soon as you get out, I would go because that's a lot of money that someone else is toning up for you to get out. Do you understand? All right.
So I just wanted to highlight, and obviously the court set the bond, I'm not disputing that, but just because there have been 2 other fugitives from Caddo Parish that have waived, and I have 6 total from Louisiana. I imagine the transport is going to be soon. So regarding financial capabilities on restoring the bond when returned to Louisiana.
So let them know, you know, what he's trying to tell you basically is that because Louisiana, we have so many people in our jails from Louisiana, we have buses coming 1 to 2 times a week to shuffle in people from and to Louisiana. So if you were to waive within the next couple days, they'll probably have you back in Louisiana as opposed to someone dropping 10,000. You said 10,000?
Marcus Taylor? So yes.
As opposed to someone dropping 10,000 to get you out to go turn yourself in within the next 2 weeks. It's up to you. I'm just letting you know what it is, and then you guys can decide what you want to do. Has she waived already?
She's waived. That's why I can stand down if you want to talk to her.
Once, because you have already waived, so we give them a certain amount of time to come pick you up. If they don't come get you within that time, we release you. Once, if you want to post bond, you have to withdraw that waiver, and you lose all the time that you've accrued toward that. I'll let it explain to you, and you guys tell me what you want to do.
Yes, Judge. Okay. All right. And Judge, I guess we need to have Bushnell and DeRoyan brought out as well for their pre-signed waivers.
Just enter in the pre-signed waivers. Unless you don't want them to come out to enter, then
I don't care. Just have them sign it and get it. Yeah.
Well, they don't really need to sign, pre-signed.
And just explain to them if they have a problem, or if they don't believe you, or they're giving you a hard time, just let me know. No problem.
Okay, thank you, Judge.
I need a public defender.
I'll give you one. But I'm telling you now, Mr. Randolph, don't be a danger to my city.
I was never a danger, just I don't intend to be in danger either.
All I want my streets safe.
It was in danger to me, and that's why I'm showing up today.
I'm going to protect my streets at all costs. You
You
understand?
protect me from these kind of people.
Enter the breathalyzer chamber, where a man stands accused of dangerous conduct. Are the witnesses' testimonies strong enough to convict him? Or is there another story hidden behind the anger? Don't miss a single tense moment of this review, where justice meets truth in a powerful collision.
Good morning, Mr. Randolph.
Good morning.
So you're charged with assault, causing bodily injury. You're facing up to a year in jail and our $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot, we're doing here. There's no reason for you to be looking out there. We're going to do probable cause. We have to find out what happened with the case.
Judge, on April 23rd, 2025, an officer was dispatched an assault call and made contact with the complaining witness, and the defendant. The complaining witness stated that he saw the defendant talking to and following a witness, and the witness then started to run away and observed the defendant to chase after the witness. The complaining witness then got in between the defendant and the complaining witness, and the defendant then struck the complaining witness with a closed fist. The complaining witness said he felt pain, and they grabbed the defendant and they proceeded to grapple until security arrived. The witness stated that she did not know the defendant and that her and her friend walked past the defendant on the street. The defendant then began to verbally harass them and started to get verbally aggressive. She asked the defendant to leave them alone, and the defendant continued to refuse to do so, and that she began to walk away and to try and get away from the defendant, but got stuck at the intersection crosswalk. Then corroborated the facts that the complaining witness provided about getting in between the two of them.
Mr. Randolph, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? I'm ordering you also now not to be in possession of weapons, not to have any contact with the complaining witness, and not to go to this part of the street. Do you understand?
Yeah.
Don't be a danger to my city, man. I'm not asking for much.
I'm not in danger. I didn't never know these people, Your Honor.
So
I need a public defender.
I'll give you one. But I'm telling you now, Mr. Randolph, don't be a danger to my city.
I was never a danger. Just I don't intend to be in danger either.
All I want my streets safe.
They
And
was in danger to me, and that's why I'm showing up today.
I'm going to protect my streets at all costs. You
Can you
understand?
protect me from these kind of people?
I'm going to have you go to Victoria, sign a reset. After that, I'm
I
going
do
to have
need a public defending office, your judge or
I already
lawyer.
told you I was going to give you one. Just really.
I'm really scared for my life because I just did 4 years and I'm going through the same thing again in your courtroom when I did good and I'm going through all the facilities. There was never in a harm's way standing 100 feet away from these people or 200 feet. I was never 100 feet within there.
Go. Exercise.
And I'm
the right-
running from these people.
You're going to say something that hurts your case. Just stop.
Yes, sir.
I'm not asking you to say anything. I just want,
I just want to also be safe in your community also.
don't use any dope. Don't use any alcohol.
Never was. I was sober that day. I was sober as can be, no drugs, nothing. Enjoying a beautiful day for my mama's funeral. I don't know these people.
Listen, just I'm gonna have you sign a reset. I'm gonna have you take your seat in the jury. Yo, I'm not talking to you. Once you sign the reset, just take a seat in the jury box. I'm gonna find your lawyer, but we need you to sign conditions. Don't leave until you sign the bond conditions.
Yeah.
Come on. I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I've ordered you not to pick up any new cases, not to violate conditions of bond, and you have repeatedly done that. As a result, I am now revoking your bond on the first case, and you will go to jail today. And I'm going to tell you, you violate conditions again, I'm going to make the bond so high your head will be spinning. Do you understand?
A man is facing the authority. He was caught driving drunk, but this isn't his first time in court. With a history of probation violations, will the judge offer him a second chance? Or has clemency run out, and prison is the next stop? Watch this tense hearing and find out the fate of the report.
You are on bond for criminal mischief. You've now picked up a new case. You now stand charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The judge. On April 26, 2025, a law enforcement officer is on patrol and observed a motor vehicle run a red light and make a U-turn, nearly striking another vehicle in Harris County, Texas. Law enforcement officer observed the motor vehicle drive onto the curb of Richmond Avenue and initiated a traffic stop. The defendant passed multiple open parking lots and continued to drive. The defendant eventually pulled into a business parking lot. A law enforcement officer contacted the defendant and observed him to be eating fried chicken. The law enforcement officer asked the defendant why he didn't lower the window, and the defendant stated he didn't have anything and continued to eat. The law enforcement officer observed the defendant did not have a driver's license and was incoherent when asked to provide his name and date of birth. Law enforcement eventually identified the defendant by name and date of birth. The defendant continued to state, I don't have anything unquestioned about his whereabouts, and standardized field sobriety tests were conducted. The officer observed 2 out of 6 clues in the HGN, 5 out of 8 on the walk and turn, and 0 out of 4 on the one leg stand. Due to the defendant, 0 out of 4 on the one leg stand due to the defendant being unable to perform the test. The law enforcement officer noted that on the walk and turn, the defendant did not turn around. He stayed still for approximately 30 seconds. The law enforcement officer explained the one leg stand, and after the instructions, the defendant began performing the walk and turn. This occurrence happened again after the law enforcement officer tried to explain the one leg stand another time. The law enforcement officer observed 2 unopened 6-packs of alcoholic beverages that were cold to the touch, and observed an empty fuzzball and a 24-ounce can of Modelo beer and an empty Twisted Tea alcoholic beverage. The defendant refused both breath and blood. A blood warrant was signed and executed.
Mr. Juarez, I'm going to find that there's enough probable cause to go forward with your case. You said he doesn't have a license, right?
That's There's a number here, Your Honor. I'm not unsure if that meant that he did not have the license at the time.
Mind running it, please?
Yes, Judge. Your Honor, he does have an eligible driver's license.
I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I have ordered you not to pick up any new cases, not to violate conditions of bond, and you have repeatedly done that. As a result, I am now revoking your bond on the first case, and you will go to jail today. And I'm going to tell you, you violate conditions again, I'm going to make the bond so high your head will be spinning. Do you understand? You're not to consume alcohol or illegal drugs, and I will put a scram on your ankle so I know that you're not consuming. Do you understand?
Your Honor, if I may,
Yes, sir.
on the first case, the court previously was testing Mr. Warwares 2 times a week, and he was doing pretty good on that for an extended period of time. In lieu of revoking his bond, would the court consider going back to biweekly testing?
Yeah. He picked up a serious case. He has alcohol in the car. I mean, he's allegedly consuming while he's driving, you know? I would figure that it's damn elementary that you're not to have alcohol in the car while you are driving. And there are multiple open containers, cold to the touch. No, I have to show you that we mean business. And me letting you go again when you have multiple violations, it's not going to happen. You go to jail. Yes. Come here. No driving. You will be signing an affidavit promising me you're not going to drive. You understand? Okay.
He's good. He's fine.
All right. This is now an order that identifies both Bustamantes as protected individuals. You cannot communicate with them. You cannot commit an assault, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, communicate with a third party to try to communicate with them. You cannot be in possession of a weapon or go within 200 feet of where they live or where they work.
I understand, Your Honor. I got 7 kids, and those are not the oldest ones.
Enter the tense world of law, where a man's fate teeters between promise and truth. With no arrest warrants on record, can Bustamante prove he's had a change of heart? Or will his continued violations finally land him in jail? Watch this dramatic hearing and find out.
Sir, you not say nothing. Nada.
You know, Mr. Bustamante, I know that there are 2 sides to the story. I get it, right? That's why we have trials. But in the interim, we ask you to do several things. And when you don't, there are serious consequences. Number 1, we ask you to show up. On your first case, you failed to appear just in and of itself, and we had to issue a warrant for your failure. We issued bond conditions on that as well. Those conditions were also broken. You've now picked up a new case. I want you to understand something and listen and hear me clearly, Mr. Bustamante. I want you to listen, and I want you to hear me clearly, because what I'm doing now is I'm putting orders of protection on both of your cases. And if you violate these, you are looking at 2 more very serious violation of a protective order case. That, in and of itself, is the capital murder of misdemeanors. Do you understand? You violate conditions on that, I can have a hearing to hold you at no bond.
I understand 100%, sir. Your Honor.
The only thing I am asking you to do is do not have contact with either of the complaining witnesses in these cases. I don't care if they're relation. I don't care if there's no relation. I don't care who they are. Do not have contact. And when I mean no contact, I mean no contact of any kind. No phone calls, text messages, social media, emails, Snapchat, whatever, maybe smoke signals, no means no.
It's a problem, Your Honor. It's not a problem.
So this is now an order that identifies both Bustamantes as protected individuals. You cannot communicate with them. You cannot commit an assault, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, communicate with a third party to try to communicate with them. You cannot be in possession of a weapon or go within 200 feet of where they live or where they work.
I understand, Your Honor. I got 7 kids, and those are not the oldest ones. I'm a good daddy.
Don't talk to these two.
I understand, Your Honor.
This order only applies to these two. Don't use the other kids to try to have contact with these. If you do,
We all live together. Right.
now you don't.
Right, I'll go to mom's house.
Best go somewhere else because they're going to inform those kids now that you're not supposed to be there or have contact with them.
That's not a problem, Your Honor.
All right.
The first one, my daughter, she doesn't live here. She ran away with her husband. Whenever she called the cops, she wasn't even at the house.
I don't,
I understand.
Don't go into
you
the
have contact with them. I'm not asking you much. You've already picked up 2 cases. You pick up a third, I'm going to blow a gasket. State, is there anything else?
Yes, Your Honor. There are allegations of drug use too. We would ask for reading your analysis.
Okay. You're not to use alcohol, illegal drugs. I'm going to randomly test you. If I find that you're using, likewise, I'm going to revoke these bonds and we'll put you back in. As it stands now, you are a flight risk. I'm not going to give you a PR bond. So what'll happen now is we're going to put you back. I've got your bond set. If you have someone that posts your bond, then you must abide by these conditions.
My daughter, my daughter.
I've given you a lawyer. You need to talk to the lawyer. You have the right to remain silent. Everything you say, they're going to sit there and they're going to type it to use it to prove your guilt. Just don't say anything. I'm telling you what the expectation is. So if you do get out, you don't pick up a third case.
I have a question.
What's the question? Ask me.
Ask the lawyer.
Okay, so, okay.
Let's step aside, Stephen,
I
Judge.
have a question.
Okay.
We're good, Judge.
You good? Okay. All right, Mr. Bustamante, you know what's expected of you from now on. That's it.
Thank you.
Okay, so we need him to sign conditions with Roxanne whenever she's ready.
You come up here so I can.
I'm not equivalent. I want to go.
Sir, please.
I don't want to go to jail.